Good morning. It's a great day here at Elville and Associates, and welcome to another edition of the Elville webinar series. I believe this is number 277 today. I'm Jeff Stauffer, Community Relations Director with Elville and Associates, and I'll be your moderator today. I'm pleased to share with you our topic, which is Learn What Elder Law Attorneys Are Advising Clients in 2024, presented by Elville and Associates Managing Principal and Lead Attorney Stephen Elville. And you're in the right place for high-level legal education. And we encourage, as always, your general questions. So please note them in the chat section or the questions panel on your screen. We'll pause periodically throughout to address them. Your questions, they always add value. They help others learn. So please note them at any time. Yesterday by email, you received the slides that Steve is going to reference in your email. So if you didn't receive those for some reason, they're also available in the section marked handouts in the panel on your screen to download at this time. For our professionals on the presentation today, welcome as well. 1.5 continuing education hours are available for most everyone in attendance. If I don't have your ID number or accreditation yet, please send that to me if you'd like to earn CE for today's presentation. And everyone will also receive a post-webinar feedback email right after the presentation. So please take just a few minutes to offer us your thoughts about today's presentation. We always read and value every comment that you have to share with us. And here at Elville Associates, we are always here and want to be a resource to your family and you. So if you have outdated documents that you have, or you want to get started with your planning, or have perhaps another matter that you want to talk with us about, Steve and his team are always here to advise and counsel you every step of the way. So I'd share with you just a little bit about Elville Associates and Steve, and we're going to jump right into the presentation. We know that your time is valuable, and we appreciate you being here today on this beautiful Friday. So Elville Associates, founded in 2010 in Columbia by Stephen Elville. We offer several different practice areas and areas of focus here at the firm, including estate and special needs planning, elder law and elder care planning, estate and trust administration, business law, guardianship and litigation, tax planning, and asset protection. We have 9 attorneys, 12 staff members, and 5 locations. Our mission, as it always has been and always will be, is to provide practical solutions to our clients' needs through counseling, client education, and superior legal technical knowledge. And we focus on education a lot here at Elville Associates, and we believe in it strongly. We do that through our planning processes with our clients. We have many different programs here at Elville Associates to suit every individual and family. We also offer, as you know, many different educational webinars and workshops in the communities that we serve. Shannon Warbeck, one of our senior associates, and I were just down at the Quince Orchard branch of the Montgomery County Public Library System a couple of Fridays ago. It was a wonderful presentation. And if you have a business or organization that you'd like us to visit, please let us know. We would love to come out and see you. And also by way of our client care program, we just had a great event down at Anne Arundel Community College 2 Saturdays ago for our first event of the year. We have another one on June 15th and our upcoming social event as well. And we're one of only 2 firms in Maryland to have an accredited client care program through the Client Care Academy in Boston. And we focus on the ideals of client education, collaboration, and compassion in mind every day with every client at Elville and Associates. Just a bit about Steve. His work as an attorney for the past 23 years has been centered in elder law, special needs planning, and estate planning, with a bit of an emphasis in the areas of tax planning and asset protection, a member of many different national membership organizations, including the National Academy of Elder Law Attorneys, the Academy of Special Needs Planners, and the National Network of Estate Planning Attorneys. Steve works to offer peace of mind to clients by creating solutions to their needs through counseling, client education, and the use of leading edge legal technical knowledge. Steve is a very seasoned speaker and presenter. If you haven't heard him present before, offering many webinars, workshops for businesses and their employees, presenting at conferences, and also continuing education events. And Steve was named to the Maryland Super Lawyers list for a 9th time and 8th consecutive year this year. So congratulations there, Steve. He also had a feature story written about him in the National Super Lawyers magazine about the Elville Center for the Creative Arts, which is our firm's charitable organization he founded in 2014. I am very fortunate to be the executive director of. So if you'd like to learn more about the Elville Center and what we're doing in our communities to work to make a musical difference in the lives of children each day, please feel free to reach out to me directly, and I'll be very happy to share our story with you. But for today, we are going to focus on elder law and what is new and what's attorneys are talking about with clients these days. So Steve, I'm going to turn the presentation over to you and make you the presenter. You should see that button pop up as always. We should be ready to go.
Jeff, thank you so much for that introduction, and good morning, everyone. And I see we have a very robust audience this morning, and I welcome you and say good morning to you wherever you are. And we know your time is very valuable this morning, so it's my extreme privilege to be with you. I'm going to get my slideshow started here. And good morning again. And again, it's just such a privilege to be able to present to you this morning and bring you some information that I hope will be very substantive to you. The concept of elder law is something that is quite ambiguous to many people. And what I hope to do this morning is help you make a transition. Many of you are on the call this morning or this webinar this morning because maybe you have existing estate plans and you are curious about where does traditional or conventional estate planning kind of translate over to elder law. What is that all about? Some of you have elder law related issues right now happening in your family with a spouse or a parent or someone like that in your family. You might be dealing with a crisis situation. You might be dealing with an ambiguous situation. And I hope to provide clarity for you this morning in that you can look at this as maybe a mini masterclass on the issue of basically what is elder law and what is happening out here in the world. Now, I am a Maryland barred attorney in the central Maryland area. We are servicing clients, because we're very blessed all over Maryland, but we also have clients in DC, the District of Columbia, and we also, of course, touch on the surrounding areas, Delaware, Pennsylvania, Virginia, and many family-related situations in and around that area. So what we're really talking about this morning is the juxtaposition, if you don't mind me using that word, of where estate planning, the traditional planning for what happens at my death and what happens during incapacity, where does this kind of meld into or transition into the world of elder law, which really is the discussion of disability. It's the discussion of asset protection in the long-term care context. It's the issue of how are we going to pay for the cost of care? It's special needs planning, it's housing, it's continuing community retirement contracts, continuing care retirement communities, it's assisted living contracts, it's all of these things. But I'm going to want you to focus, if you have a tablet, if you have an iPhone or other Android where you can make notes, or a piece of paper or a computer, I want you to be ready to write down some key issues here, because we're going to be very efficient. We will take time for questions, but we're going to be efficient with your time this morning, and we're going to start on time, which we have, and we're going to end on time. But these are the issues I want you to be thinking about. How can I get my mind around this idea of elder law? And again, what does it represent? Well, you're going to get a lot of information on that today. I want you to think about a key concept that's going to come out. It's going to come out in unexpected ways. Level of care. When we're talking about elder law, we're talking about someone who is either planning in a pre-crisis mode. A crisis hasn't happened yet, so this is very much like advanced estate planning for asset protection, versus someone who is older or younger, God forbid, and is becoming disabled through a progressive illness or some other type of disability. And the issue of level of care, what is that person's level of care? That is going to be a key concept that hopefully will become more obvious as we go through. But that's a subtle thing that most people are not aware of. And especially in Maryland, it's going to be a key issue, whether you're dealing with a loved one now with disability or you yourself are thinking about your own potential disability. Level of care determination is going to really be a big issue, not only about where you might be living or your loved one is living, and how they should be cared for, but what is the state of Maryland going to pay for people that are disabled versus what will it not pay for? And unfortunately, Maryland, where I'm barred, is maybe one of the worst states in the country for paying for long-term care costs that are short of a skilled nursing home. So in other words, being able to live at home, being able to be cared for at home, or being able to be cared for in an assisted living environment, and having the state of Maryland pay for it is just not going to happen for most people. As it does happen in a more robust way in states like Delaware or in New York, we are just not one of those states. So understanding the level of care and what is the person's need and how that equates to whether or not it can be paid for by the state is one of the aspects, not a huge or the only aspect, but one of the major aspects of what we're going to talk about today. Financial powers of attorney, as you continue your list of key things. Financial powers of attorney are the most important tools, not in just elder law, but in estate planning in general. The most important document from a legal point of view, arguably, is the financial power of attorney. A good way of thinking about this is this simple story. I was notified about 3 months ago of a very, very serious health issue that a professional that contacted me, their relative had this issue and was in the hospital. My first reaction was, what is that person's power of attorney? Does that person have a financial power of attorney, and what does it say? Now, perhaps my first reaction should have been, does that person have an advanced medical directive because they were in the hospital? But from an elder law perspective, when I found out that she had several minor children and this person was facing a serious issue, health issue, my first reaction was, what is and where is the financial power of attorney? Because that financial power of attorney holds the key to what kind of flexibility a person has under a situation of incapacity or disability. So financial power of attorney, write that down. Income. Income is key in elder law. Income, whether in most of the time fixed income, pension income, income that can be created from investments. These, as you're going to see throughout the presentation, are the key elements. When someone has significant income, that is going to take care of a lot of our worries about long-term care. Not all of the worries, but a lot of it. Long-term care insurance, for example, is a source of income if we are disabled. So fixed income, investment income, income by way of a long-term care policy, key issues. And then I mentioned earlier, and then we'll get into the slides, cost of care. So the cost of care continues to rise. The cost of care is extraordinary, as we know. And the cost of care in assisted living and in memory care is extraordinary. And we won't spend time going into the numbers today, but those of you on this webinar who have relatives in assisted living, you know what I'm talking about. And if those relatives are in Maryland, there are very few options for those relatives to receive any kind of assistance from the state of Maryland. So the creation of income, the financial advisory aspect of the collaboration between an elder law attorney, the client, the CPA involved on the tax side, the financial advisors involved, all should be working collaboratively to create income and assets. And if you're a person who has moderate assets or your family has moderate assets, then we're going to be keenly interested in some of the issues this morning about what happens when we become disabled, how do we protect assets, and how should we think in terms of this with the financial power of attorney at the center, kind of at the center of that universe. So thank you for listening to that really elaborate opening, but I wanted to set the stage now for the following slides. So we're going to talk about the trends in Maryland planning, federal law and the Affordable Care Act, major problems that Maryland has that I mentioned, waiver slots, we're going to talk about that, the waiver programs in general, okay? We're going to talk about the augmented estate. Some of this is going to be understandable and some of it might go over your head. If it does, do not worry. These elder law concepts are not intuitive. They are counterintuitive, and it might take a couple of times talking about this. It might take an in-person meeting to talk about this. We've talked about the cost of care. Let's not forget about elder abuse. And Jeff, later in the presentation, please don't let me forget to talk about elder abuse. And I would like you to share Officer Andre Lingham's charitable organization that fights elder abuse, and just give us the statistics, if you would, Jeff, later on about elder abuse. We're going to talk a little bit about supported decision making. And as we now get right into this presentation, remember, this is not legal advice. This is really high-level education. So I want you to take it as such. And we could go into a legal relationship, like an attorney-client relationship, with an elder law consultation, or just a review of your current estate planning documents. Or if you don't have any estate planning documents, don't be upset. We can certainly address that issue, as well as any competent estate planning attorney. So why are clients coming to see elder law attorneys in 2024? Well, it has to do with age. Obviously, we're all getting older, age-related impetus. It goes without saying that many people we have in our firm as clients, dear clients, will live over 100. We've had several people live over 100, most recently someone who lived to age 104. People are living a long time, so we have this age-related impetus. There is the concept of pre-crisis planning that I mentioned, getting ahead of the asset protection issues. This can be a driving force for someone, but remember, all planning is goal-driven. If your goal is to protect assets or get ahead of the curve, so to speak, that pre-crisis planning is one of the major reasons people come to talk to estate planning or elder law attorneys. Changes of circumstances. Unfortunately, some people experience this. Maybe some of you have experienced a spouse or loved one who has had a health crisis. This is going to cause a change of circumstances. Perhaps the planning initially was we would call conventional estate planning, routine estate planning, which should have included wills or revocable trust, financial powers of attorney, and an advanced medical directive, plus maybe other things like a standalone HIPAA waiver, and perhaps making sure there's a collaborative team of advisors. But now there's been a change of circumstances. There's been a stroke, or there's been some kind of a progressive illness like Parkinson's or Alzheimer's. These are the reasons that precipitate changes in the planning, obviously. And I just mentioned this, crisis, or there are parents, aging parents, and there are all kinds of issues. Hopefully you are a person, if you have aging parents, that is a family that cooperates, a family that gets along. The harmony of the family is there. And that makes the planning so much easier. But if you're not one of those persons, and the planning is going to be more complex because the parents and the family members are not in harmony, then we need to address that in a different way. Grandparents, of course, disabled children, special needs planning, not only for spouses, but for children and others. And I think we've covered this now, so we're going to go on and move forward. We're going to continue to talk about the issues in more granular level. Healthcare decision-making. I would challenge you this morning, since you're so good, so devoted to get on a webinar like this and talk about these issues on a Friday morning, look at healthcare decision-making law in Maryland. Go to the Attorney General's website, which is pretty boring actually, but you will be able to see healthcare decision-making in Maryland and the policy. You'll also be able to see the most form and the most information, the medical order for life-sustaining treatment. Educate yourself. Financial decision-making. Obviously, we just talked about the financial power of attorney. Families need to understand these documents. Maryland continues to update some of these documents. We're going to talk about that. But the general durable power of attorney is that foundational thing. How much flexibility do we have in an existing power of attorney? How much flexibility do we want to build in? That is a key question. In-home care, are we addressing that issue properly through insurance and understanding the licensing and understanding the risks of having people come into the home? Are the wages and salaries being properly dealt with for tax purposes? Nursing home and assisted living placement. These are involving contracts. They involve financial obligations. They involve Medicaid applications. And in the context of assisted living, they involve private payment. And this is a huge issue, not only because of the liability involved for families, but for the size of the payments. So these issues have to be dealt with very carefully. Estate planning, we talked about that, the conventional planning for what happens at death, what happens during life. Asset protection, we're going to talk this morning about the various aspects of asset protection. So asset protection is not just what happens to protect me from bankruptcy or from lawsuits. Asset protection has to do with elder law as well. Understanding and limiting liability. Some people who are acting as agents for their loved ones are concerned about liability, understanding that and how to limit it. Again, we talked about assisted livings, nursing home contracts, continuing care retirement community contracts. And I'm just going to scroll down here just a little bit, Jeff. It looks like our slide is a little bit cut off at the bottom there. Medicare, and I can't read the bottom slide. It's cut off, Jeff, but I'm going to just continue on.
Special needs planning, Steve.
Special needs planning. Thank you, Jeff. I don't know why it was cut off there. So special needs planning, of course, is near and dear to our hearts at Elville Associates. We have been very privileged to be an integral part of the estate planning and special needs planning community for years. Special needs planning is not only for children or others, it involves the entire extended family if done properly, but it also is for spouses. So there is a technique to be able to do special needs planning between spouses to be able to preserve assets. Okay, thank you for, again, staying with me through that intensive overview of the beginning of the presentation here. Now let's get into the weeds a little bit about what is an elder law consultation. Well, one of the first things I was ever taught as a young lawyer was how to do an elder law consultation. And I was very fortunate to be able to, rub shoulders with some of the more prolific elder law attorneys in Maryland, and I will say nationally as well. And I have found that this is really where the rubber meets the road for families. Many families are dealing with a sea of ambiguity. There may be this beginning of a crisis or progressive illness. Many people are doing self-help, and then there's a lot of myths out there. There's a lot of misinformation. Some of it is extremely upsetting. Some of it is extremely frustrating, as some of you on this webinar will agree. And what we want to do in the elder law consultation, which generally takes a couple of hours, is really get down into the fact finding and listening, okay? Listening, identifying the problems, identifying the client goals, okay? And really getting down into the incapacity related issues, because again, that is the heart of elder law, the incapacity related issues. It's not just whether a person is incapacitated, it's a question of what happens if I'm incapacitated and what is the scope of the flexibility. Understanding long-term care issues, medical assistance, which is what Maryland calls Medicaid, the asset protection techniques, which we're getting ready to get into, cost of care and long-term care financing, how does that work? Discussion of the advisory team. I mentioned this earlier on. To me, you are not going to be well served if you just have one advisor. You're going to want to have an elder law attorney, a CPA, a financial advisor, and possibly a life insurance professional, and possibly a life care manager. A life care manager, let's talk about that for just a second. A life care manager is someone we used to call a geriatric care manager, but now they're called aging life care managers. And we at Elville Associates are lucky to be able to really have relationships with some of the really great life care managers out there today. These people can assess levels of care. Remember, that's a key. These people can be a real advisor to you as you might deal with on-the-ground situations with your loved one or someone with disability. And I strongly recommend if you have a situation that you need a life care manager, you need advice, you need someone who can collaborate with your elder law attorney, we strongly recommend you get in touch, or we will get you in touch with an aging life care manager. Recommendations and next steps. This seems like a simple thing, but when I was a young lawyer, I experienced situations where I was in the attendance or in the audience of other senior elder law attorneys, and I saw that many times they didn't give people, as strange as this sounds, really clear next steps. And I have found that clients are wanting answers, they want next steps, they want to know, what can I do to protect ourselves or our loved one? What can we do to affect change? So a good elder law consultation is going to provide steps, action steps that are tangible and measurable. Now, an elder law consultation also many times serves as a basis for a shift in the planning. As I mentioned earlier, and we keep being redundant here throughout the presentation, intentionally so as to drive home information. So when we are in a planning situation, we may have done planning years ago. Hopefully you did, because if you did planning, you are in the minority. The minority, not the majority, the minority of people in this country do planning. So when you do planning, you are in the minority and you should be proud of yourself. But now that planning needs to shift. Some people come to the elder law consultation with no planning, but I'm happy to say most people do have some kind of planning in place that we seem to deal with, where there is at least some kind of financial power of attorney in place. If there is not, then we have to explore creative ways to be able to get one in place, or to deal with a situation where we don't have that flexibility. So sometimes it's the shift in planning that happens. The elder law consultation resolves ambiguities and many misconceptions. It relieves anxiety and hopelessness. Many of you have felt hopeless. Many of you have had loved ones that are so frustrated and exhausted, to be honest with you, that they need direction. They need to get past these myths and ambiguities. And that's what I'm proud to say that a good elder law consultation will do. And I've seen the sense of empowerment that it gives people, and it creates a foundation for family unity that hopefully already exists. But if it doesn't exist, it addresses weaknesses in family structure. So as promised, we are now about 25 to 30 minutes into the presentation. I'm going to shift into asset protection. So when I say the financial power of attorney is the heart of elder law, well, the financial power of attorney as the center of the universe, in my opinion, really is going to determine how that financial power of attorney is constructed, is going to determine how much asset protection possibility there is. And not all clients want asset protection. Some clients say, hey, if I'm disabled, if I'm really suffering from a long-term illness, I want my assets preserved for me. I do not want them used for others. I don't want them gifted to others. I don't want them transferred to my family. I want them to be used for me. And there's nothing wrong with that. But many people want the flexibility to be able to preserve their hard-earned assets. Please take care of me, but if you can preserve some of my assets, please do that. So that's what we're going to talk about here. But to understand asset protection, you have to understand the context of what asset protection is. So hopefully I'm leaving no stone unturned for this audience today to understand that we have asset protection in at least 3 different categories. How are the assets we may own protected during our lives? And many of us don't even realize we have some of this protection. How do we protect assets at death? And I'm going to illustrate that. Plus, how do we protect assets in the thing we're talking about today, the long-term care context? So many of us are married, and if you're not married, that's okay. Please just bear with us through this. If you are married and you live in Maryland or even Delaware, you have tenants by the entireties as a possibility of ownership. So between spouses, you can own property tenants by the entirety, which means that if only one of you were to get sued, to make a long story short, the asset could not be torn in half and the asset would have some protection. Unfortunately, if they sue both of you, you would not have asset protection in the asset. Brokerage accounts, houses, anything that is a non-retirement asset can basically be owned as tenants by the entirety. Life insurance, if your child is the beneficiary or your spouse, is protected from the claims of creditors in Maryland. Annuities are protected for the same reason. IRAs are protected from the claims of creditors. Qualified plans are protected, like 401ks. But inherited IRAs, IRAs that we leave our loved ones at our deaths, are not protected from general creditors. We have to basically acknowledge that due to a Supreme Court ruling several years ago. And then domestic asset protection trusts, such as asset protection trusts that can be developed in states like Delaware, Nevada, Alaska. These things have nothing to do with long-term care protection, but this is one aspect of asset protection, and you need to understand the difference. Now, as we look at long-term care asset protection, we now start talking about, well, what if we use certain tools that are available? What if we were to divest assets? Now, remember, I've put so much emphasis on the financial power of attorney. Your agent cannot divest assets. They cannot take advantage of some of these tools or these laws if you do not have a financial power of attorney, number one. Number two, they can't do it unless you've provided the flexibility in the financial power of attorney. So a lot of what I'm saying here is not only something you can do during your your lifetime, but it also has to do with, do we want our agent under a financial power of attorney to be able to do these things? So a Medicaid asset protection trust, that's a mouthful, is a very powerful tool, and arguably maybe the most powerful estate planning tool and elder law planning tool we have today. So if those of you who have not heard of this, we are happy to share this with you and kind of juxtapose the Medicaid trust versus a revocable trust or will planning. So this is a powerful tool. One of the hybrids of that trust is a veterans asset protection trust. Some of you or your loved ones have served in the military and are eligible for the aid and attendance benefit. So this is something that is an ancillary and a little bit different structure of the veterans trust, but it's designed to allow a veteran to receive a tax-free income if they qualify, as amongst many other VA pensions. And also it's allowing them to have the certain advantages of being able to divest assets and still retain some level of control over them. Wills that have trusts that are established under them for a disabled person. So we can create trusts, especially between spouses, that there is certain federal and state law that protects spouses that are surviving. So a surviving spouse that has disabilities can be protected. This is an aspect of what we would call special needs planning between spouses. Spouses that have an impairment or a progressive illness. Now, when we look at crisis planning, we are looking at a couple of different things. If you are in pre-crisis planning, we know that we can get assets out of our names, get assets out of our Medicaid estate, so to speak, a little bit of different language here than regular estate planning, and get those assets divested out of our names well before they would ever be needed for long-term care. So there's a 5-year look period. This used to be 3 years up until 2005. So if we can get ahead of that planning, we can do pre-crisis planning. But crisis planning, on the other hand, is something where we maybe didn't get past that 5-year period. So now we are going to have to rely on certain things such as spousal spend down rules if you're married. So if you are married and you had to do a Medicaid spousal spend down, your loved one was in a skilled nursing home, not an assisted living, you will not, with the right and proper advice, you will not lose your home. You will not lose most of your assets. You'll be able to preserve most of them, even though the federal law is not perfect. But it does make an attempt to allow you to preserve most of your assets under most circumstances. If you are in a crisis situation and you're not married and there has been no pre-planning, then we could engage in a rule of halves strategy, a 50% strategy where pretty much up to around 50% of the assets could still be preserved. There are life estate deeds that are able to be structured without powers. These life estate deeds also start the 5-year period, albeit with not the same flexibility as a Medicaid trust. So asset preservation, we have certain asset protection during life. We have asset protection strategies that we could engage in Medicaid planning. And then at death, we'll be very brief about this in the interest of time. At death, we can plan for spouses or children, and we can plan for people who are at risk, like special needs beneficiaries, and we can plan with all kinds of flexibility. We can protect them through spendthrift provisions that protect them from the claims of creditors. We can have flexibility through the use of trust protectors. And structuring trustees is critical and perhaps one of the most important things in planning today. Who will be my trustee? And Jeff is happy to send anyone who wants to see this, the webinars that we do on trustee selection. So just know we have various webinars that can be reviewed. So hopefully what I've illustrated in the last 5 minutes or so is asset protection during life, asset protection in the long-term care context, asset protection at death, which we can establish for our loved ones. Now, many clients in the elder law consultation are going to ask these questions, and many of you have these same questions. How can I pay for the cost of assisted living? Because, unfortunately, Maryland is not one of those great jurisdictions where there's a lot of robust funding to pay for assisted living. How do I care for long-term care in a nursing home? Will I lose my home? This is something I just addressed. How, if I am a spouse, how will I survive in the community? How do we preserve our assets? I promise there are answers, and if you've been told anything to the contrary, most of the time it's not true. So we have to get to the heart of the real facts. What do I do? How do I deal with placement? We talked about aging life care managers. We talked about using them as a tool. Elder law attorneys can also help place people in a nursing home or assisted living. How do I make healthcare decisions for my loved one? And do I need a guardianship? See, hopefully, through the proper financial power of attorney, we are going to be able to avoid guardianship, or through the use of supported decision making. Can I get veterans benefits? Well, there are new rules as of 2018, which now seems like a long time ago, but those rules are good and bad, mostly good, to give us more clarity about certain veterans who qualify for the tax-free benefit and their spouse aid and attendance benefit. How should I title assets? We get this question all the time, and there are certain ways that you should be concerned about how assets are actually titled and how they affect asset protection, how they affect long-term care planning, and so forth. How do I deal with or care for my impaired loved one? Again, aging life care managers and other professionals in the collaborative team can help. How do we deal with a continuing care retirement community? Can we still preserve our assets? Well, the answer is generally no, because you're entering into a contract with the CCRC. But can I still get veterans benefits? Yes, depending on your other qualifications and life circumstances. So the client is confronted, whether that is your parent, whether that's yourself, or you as you deal with your aging loved one or spouse or child with disabilities. Do I make changes to my plan? Do I have to make hard decisions about health care? Obviously, one of the most heartbreaking situations is when one of our loved ones has to be placed in a facility. This is heartbreaking. I've experienced it myself in my own family. So the placement, transfer of assets, levels of care, there we go again. Understanding the level of care. We don't have time to really elaborate on that this morning, but just trust me when I say understanding that is going to be huge, huge for you as you go forward. Now, as we start to get towards the middle to the end of our presentation, I just want you to kind of get this sense that when you or your family or your parents come for an elder law consultation, you're generally going to get all of that information that I just described. That's what elder law attorneys are doing, amongst other things. elder law attorneys are still doing regular estate planning. Elder law attorneys are still dealing with people of modest or low wealth and also people of great wealth, because these issues touch, or at least moderately middle wealth, because these issues touch on many, many people and their loved ones, even if it doesn't affect a particular person or spouse. So there's a lot to do and a lot to take away. So for a married couple, we're going to be looking at things like this: building flexibility, addressing the cost of care in advance, doing full educational counseling, not just with the couple, but with their kids, with their trusted fiduciaries. Many times this is going to just basically end up as a wait and see approach, or perhaps there's going to be asset transfers between spouses for various reasons. Maybe we are going to be getting assets out of an ill spouse's name at a particular appropriate time. Or maybe there's a crisis going on, so we're going to have to engage in asset preservation from the get-go, so to speak. For an unmarried person, we are generally doing the same thing, except under the umbrella of the medical assistance rules, of the Medicaid rules, the single person does not have as much flexibility, unfortunately. So we are really going to be looking at things through a much more sharp focus on the limited things that are available to us to try to preserve assets, if that's a goal, and to get the flexibility built in, if it hasn't already, in doing the same counseling, doing the same cost of care analysis, dealing with the advisory team if there is one. If there isn't one, getting one in place. Let's talk about the nuances of incapacity planning, as I've now hopefully not worn you out with this issue of the financial power of attorney, but let's talk about incapacity planning, because really that's what we're talking about here in elder law. As unpleasant as it is, and I commend you again for being on this webinar this morning talking about issues that are very difficult to talk about. So remember, we are avoiding guardianship. We are avoiding guardianship of our person under the advanced medical directive by appointing an agent. We are avoiding guardianship on the financial side by appointing our agents as well. And what do we want? We want to think carefully about who our agents are, and we want to ensure to the best degree possible that the design of our documents is enhancing the possibility that our agents are going to what? Get along for the long term and cooperate together to help you and advocate for you to avoid guardianship of your person and property. Maryland is fortunate, I believe, to have a statutory power of attorney, a power of attorney that's actually in the law. It is enforceable by law. It is something that you can rely on if you are a Maryland resident. And we've had this since 2010, since the Maryland Power of Attorney Act. This is gone a great distance, a great ways towards cleaning up the problems with powers of attorney. We still have plenty of elder abuse, still have plenty of problems with powers of attorney. However, just like the District of Columbia, the state of New York, the state of Delaware, the state of West Virginia, Maryland has a statutory form, and this should form the foundation, in my opinion, of your incapacity planning. There's no downside to it. Although there are some new optional powers in the Maryland Power of Attorney that I think you should be aware of, and that would be a counseling issue. But the Maryland Power of Attorney, in my opinion, in the context of elder law, is not enough. It is not customizable enough. It is not specific enough about the things that you would normally look at. Not every person is going to be the same, but in general, the kind of flexibility that you would want to build into your power of attorney would not be enough if you simply relied on the statutory form. So you're going to want to be thinking about having a general durable power of attorney in addition, so that you can customize your approach to flexibility and what you want and what you don't want based on what your goals are concerning asset preservation, taking care of yourself, and giving a large envelope of authority to your loved ones if that is appropriate. And if it's not appropriate, to bring in or shrink down that envelope of authority. So that every situation is going to be the same, but you have to be cognizant of the importance, again, of the financial power of attorney. I'm not going to go through every one of these Maryland statutory form slides. These are for your use and kind of knowledge, but these are the kinds of things that you would typically want to consider in addition to others that you're going to want to customize in a financial power of attorney. Now, we've been talking about the asset protection context. Let's get back to the medical decision context here. We're going to advise you to please think about customizing your advanced medical directive. The medical directive is flexible. It is not formal. It's informal. It is not hard and fast. It does not have to be in any particular form. There are various types of advanced directive. To me, the Maryland Advanced Directive is very, very good because it allows for a great ability to customize it. You don't have to customize it at all. As long as you have one and as long as you've completed it, you should have waived HIPAA. You should have appointed your agents. You should have decided your end of life decisions. You should have decided when the agent's power becomes effective, all of those things. But beyond that, this simple bullet point slide shows you some of the things that you can do above and beyond that, and you can customize your advanced directive much more than just a basic form, and you should know that you can do that. The advanced directive doesn't even have to be notarized, but of course we make sure that they are notarized. That's how informal it is. So for better or for worse, this is a very informal document, and I encourage you to take it seriously because this is the only thing your agent will know about your healthcare thoughts and feelings, your desires, other than what you have told them. That's why I want you to think about customizing this.
Steve, a brief question.
Yes, Jeff.
You mentioned that Maryland is not good in paying for long-term care. You mentioned Delaware and New York as good states. Any thoughts about Pennsylvania?
Well, thank you for that. And I don't want to hold myself out as the authority about this, but my understanding through, even though I'm not barred in Pennsylvania, is that Pennsylvania probably is more likely than not to be similar to Maryland, even though a good certified elder law attorney in Pennsylvania would be very helpful to answer that question. But when I say that states like Maryland do not have robust waiver programs, here's what I mean. And then you can use this as a context. And Jeff, I'll go into this for 2 minutes because I think we have time. I would think very simply, even though the Medicaid system is not simple, I want to kind of encourage you, in my opinion, as a practical matter, to think about Medicaid in 3 categories. The first category on the left is community-based Medicaid. I live in the community, I have limited assets, and I have limited income, and I need health benefits, I need food stamps, I need housing. That is a social services benefit, and that is unlimited, state and federal. If I'm in a long-term care nursing home, skilled nursing home, and I meet the requirements of residency, citizenship, and financial aspects, I'm going to receive care in a Medicaid nursing home, state and federal, unlimited. But in the middle, we have what we call the waiver programs, and that gets to the heart of this question that was just asked. The waiver programs are basically programs that the federal government tells the states that they can limit. State, you can limit this particular program. So there is adult daycare waiver, the autism waiver, traumatic brain injury waiver, these kinds of waivers, and then we get to the community options waiver. So that waiver is the one that would allow someone to live at home or in assisted living and receive Medicaid benefits at home or in assisted living. And Maryland limits those slots, unfortunately, so much so that very few people qualify, and there are income limits and so forth and asset limits. And I'm just going to say at any given time, there are 20 to 24,000 people, let's say, on the waiting list. So just to put that whole thing in context, that is why we in Maryland are not one of those states where there's a robust waiver program. I have not heard that Pennsylvania is a robust waiver state, but I could be wrong. I do know that Delaware and New York are much more robust than Maryland. And many times in elder law, we are talking about jurisdictions. And this is one of the things, Jeff, maybe for next time, that we should always bring up in one of our bullet points is elder law attorneys are talking about jurisdictions. Should I continue to live in Maryland because of the onerous laws that don't pay for or provide for any care? And I realize that this is a political and personal issue for some people as well. But generally speaking, we many times are consulting with people about whether they should live in Maryland, whether they should live over the border there in Delaware, because there might be better benefits in the long-term care context. So thank you for that question. As we begin to work towards the end, we're going to be efficient. The medical order for life-sustaining treatment is required by Maryland. It's one of the only states that does require it. This is something you should be aware of. We have had aging life care manager Jill Rossner weigh in on this issue, and she is of the opinion that many people should have most forms even if you don't live in a facility. So these are elder law related issues that we could further talk about or get you connected with a life care manager, or also just speak to your physician. So as we are trying to leave just a few minutes here for questions and answers, and we are making an attempt to be more efficient in our webinars and get done a little earlier because we know it's a Friday. We know many of you are very busy, and I thank you so much for spending time on this webinar. I hope what I've done is given you something substantive, 1 or 2 or 3 tools that you could walk away with. And I'm hoping you also walk away with the peace of mind of knowing that as long as you have high level advice, you will not lose your house, you will not lose your assets, all of your assets. And some of these things that are told out there, that are proliferated out there, are very harmful, very hurtful, and very upsetting to people. So we encourage you, whether you have existing estate planning and you are curious about how to start thinking about elder care planning as you transition in your life, please set an appointment with us. Jeff will help you. I will help you. We want you to complete an elder law or estate planning questionnaire, and this will get us to know more about you. If you don't have planning, believe that there is nothing to fear. We want you to relax, and here's why. When you come forward and you talk to an attorney, if you've never done it before, or if you've never talked about personal issues relating to planning, it's a very strange experience to share personal information. There's no question. But we want you to know there's nothing to fear, because there's an attorney-client relationship. Whether you become a client of Elville & Associates or any other attorney or not, there is an attorney-client relationship. Everything is confidential. So bring your current documents if you have any. Bring your questions if you have any. We love to answer questions, and we appreciate that question this morning, or that couple of questions. We want to help you form an advisory team. If you have a financial advisor, we want to talk to them. We want to collaborate with them. If you have a CPA, we want to collaborate with them. And if you have a team, and we're fortunate enough to become part of your team, we want to make sure that all of the team members are talking. And moreover, we want to give you the time to think, because many of you are concerned about these issues. You're concerned about the state of the world, the state of the Medicaid system, the state of the nursing homes and the assisted livings in our state and surrounding areas. And we want to give you the time to think. That's what many people don't really have. And so we want to give you that in our high-tech conference rooms and our focus on client education and counseling. And with that, the bottom line is we want to help you identify your goals and achieve those goals. So thank you for sitting through that. I hope in that barrage of information, and with Jeff providing a copy of this PDF to you, that you're going to use it as a tool. You'll treat it as a mini masterclass, and you'll come back and let us know if you have questions, or you would like to review your financial powers of attorney, review the fundamentals, and or talk about a spousal situation or special needs situation or aging parents or other situation that you may have, or any other question we can answer. Jeff, I'm going to turn it back to you, and just remember, if you would, please talk about the elder abuse aspect after we talk to people about how they can get in touch with us, and just want to make sure we talk about that before we leave.
Yeah, absolutely. On the tip of my tongue, Steve, we have a few questions, but I do want to talk about elder abuse for just a couple of minutes. So we are fortunate, we know many advisors here, but we're also fortunate to know Mr. Andre Lingham, who founded the Center for Elder Justice and Education about 4 years ago at this point, I believe. He has been a friend of the firm here, helped many of our clients, and people have just called in looking for help and resources. Right now, it's been reported that people lose about 30 billion, that's with a B, $30 billion a year to elder abuse and fraud for people over 60 years old each year. And that's just what's reported. It's much, much higher than that. And 90% of that is through people that the victims know. So it's not just strangers. 90% is for people that they know. And so it's really a serious issue. And Andre founded his center, which is a 501c3 nonprofit, and it works with families and individuals that are victims of abuse, fraud, identity theft. He'll work with you. He's a former decorated Howard County police officer, also the senior citizen liaison through the Howard County government for aging. So he's very, very well respected in the communities that he serves, and we're very fortunate to know him. So I will send you.
I think you have a webinar, Jeff, that you can send out to people or invite to his next event. Yeah.
So he has presented on our series several times about 2 different presentations on fraud and identity theft. He also presented at our client events this year. I think he's going to present again this year on a different topic. And we're very excited to have him back. I'll send you his 2 presentations that he offered to our attendees, which were extremely well received. And also send you in my follow-up email that I always send out all of his contact information and resources. So he's a wonderful guy and somebody that if you know somebody that you feel is a victim or may be a victim of elder abuse or fraud or identity theft, you want to reach out to him and he will help. He's helped a lot of people and it's just a wonderful resource. So, very important information. We do have a few questions here, Steve. Let's go ahead and take care of those. And we'll go ahead and call this one a success. First question, does MOLST require a doctor's signature to be effective?
Yes, thank you very much for that. So MOLST does require a doctor's signature or that of a nurse practitioner.
Okay. I have a revocable trust from my assets in Maryland. I plan to move to a CCRC in Ohio. Will this protect my assets or do I need new documents in Ohio when I move?
That's a wonderful question. Just taking the high level questions you're asking, when you move to Ohio, you typically would make sure that you affiliate with a new estate planning attorney there that can help you and be your resource. And typically, although I can't speak for them, they would probably suggest that you move the location and the state law of your trust to Ohio. So that could be done maybe through a restated trust. And when you talk about protection, remember your revocable trust, if that's what it is, does not protect your assets from long-term care creditors. But when you live at a continuing care retirement community, depending on what the contract is, you are probably going to be somewhat prohibited from being able to engage in asset protection for long-term care, because in essence, your being at the facility is basically saying that I'm going to use my assets typically until they are no longer available. So protection, what your question is probably meant to mean protection from probate, but not protection from long-term care costs. And good luck to you in Ohio.
And regarding the question about paying for long-term care, you mentioned a couple of states. Knowing that you're not necessarily a Virginia attorney, any general brief thoughts about the state of Virginia, literally?
Yeah, thank you. Yes, I'm not barred in Virginia, but I've worked with several certified elder law attorneys in Northern Virginia in particular, and my impression is, subject to further verification by you, is that Virginia is going to be very similar to what I talked about with Pennsylvania, that I don't perceive that there's any real robust waiver programs, although only a certified elder law attorney or other elder law attorney in Virginia could really answer that. But that's my impression.
Okay. And last one for now, and now would certainly be a great time to get any final questions in for Steve. Again, knowing you're primarily Maryland centered, DC residents have a trust and will. Any new laws, et cetera, on elder care in DC, if any?
Gotcha. Well, I would strongly recommend, thank you for that question, is to reach out to our elder law associate, or I should say principal, Lillian Hummel. Lily is our new elder law attorney at Elville and Associates, who is a principal attorney now. And Lily is the current chair of the Montgomery County, Maryland elder law section. We're very proud of Lily, but also Lily is barred in the District of Columbia. So I think that if you could, Jeff, maybe direct this person, if they want to provide the information, Lily could follow up with you on that and maybe do a review with you.
So, ma'am, I will gladly follow up with you and give you Lily's contact information. And if you'd like to follow up with her directly, that'd be terrific. I think that'd be a good resource for you. So, okay, well, I have some follow-up to do for you, as Steve alluded to, and I'll get that out this afternoon. And just real quick, we have, as I mentioned yesterday, if you were on Shannon's presentation, we have some really great presentations coming up in just 30 seconds here. May 14th with Steve, we're going to get back to the essentials, estate planning and elder law essentials. And then May 16th, we have our first guest presenter of May, Marie Ritzenberg of Main Street Home Loans. She came into our office and did a presentation to our attorneys and staff about the family opportunity mortgage. It was so good, we thought we need to make this a presentation and share it with our clients and others. So the family opportunity mortgage, empowering families seeking to provide housing for loved ones, something that you really want to learn about. Lastly, for now, May 23rd, life and long-term care insurance in today's marketplace. This is a topic that in our surveys is arguably the one that people have asked for the most. So we have Max Reamer, an advisor with the Quantum Group, who presented at our client event last November, coming to talk about that topic. So a few really great presentations coming up and certainly more to follow. But for today, that is a wrap, and we appreciate you being on today's presentation. Hope you have a really great weekend, and thanks for being part of the Elville webinar series. We'll see you again soon.
Thank you, everyone.